Imagine you have just spent 5 years of your life and, I don't know, maybe $50 million in venture capital building this completely revolutionary piece of technology.
Yeah, you've optimized your supply chains, scaled the engineering team, all of it.
Exactly. You are finally ready to deploy into the United States market. And then you get a notification. A foreign entity one that is heavily sanctioned and completely locked out of the U.S. market is suing you in an American federal court.
Which is terrifying on its own.
Right. But here is the truly terrifying part. They do not care if they actually win the lawsuit.
Not at all.
They are suing you because the U.S. federal court system mandates this process called legal discovery. And through that mandatory process, they can legally force you to hand over your source code, your internal JIRA tickets, and your most sensitive trade secrets, essentially on a silver platter.
They don't need to hack your servers, they just file a patent suit.
Yeah. Welcome to the deep dive. For those of you just joining us, we are executing the system architect protocol today. That means we are bypassing all that surface-level business news, and we're speaking directly to you, the CTOs, the engineers, the founders building scale-ups outside the U.S. Our mission today is highly specific.
We are analyzing the rapidly shifting architecture of American intellectual property.
And this is based on some crazy news source material, right?
Yeah, we are basing this entirely on the structural realities exposed during a recent, highly contentious House Judiciary Oversight hearing of the U.S.PTO featuring Director Squires.
Okay, so to navigate what I just described in that intro, that absolute nightmare scenario, legal discovery used as an extraction protocol, we kind of need to establish our operational lens for this analysis immediately.
Right. If you are a CTO operating a scale-up outside the U.S., you can no longer afford to view intellectual property as, just a collection of static legal documents drafted by attorneys and filed away in some dusty drawer.
No, you have to treat IP claims as code.
Exactly. You must treat IP portfolios as distributed systems. We are not discussing legal theory today. We are analyzing structural deployments in a rapidly fracturing global network.
And right now, the American Registry, like the central database of that network, is undergoing this massive, completely contradictory architectural shift.
It really is. Which brings us to the core paradox of this entire deep dive. If you look at the U.S.PTO right now, you are looking at a system administrator that is basically fighting itself.
Yeah, it's wild. On the front end, the U.S.PTO is aggressively subsidizing rapid deployment. I mean, they are greasing the wheels. Director Squires testified at length about their new ASP AI pilot program.
The AI subsidization is massive.
It is. They are using artificial intelligence to compress prior art searches from what used to be these agonizing, weeks-long human endeavors down to a mere 5 seconds.
5 seconds?
Yeah. They're generating automated top 10 lists of relevant prior art and delivering them to examiners before the first office action even occurs. So they are hyper-accelerating the pipeline to push patent code into production.
But then, simultaneously, on the back end of the exact same system, they are engineering a massive discretionary chokehold.
Right.
They're building this strict practitioner firewall backed by Rule 11 accountability. So as a system architect looking at this, it makes absolutely no sense on the surface.
It really doesn't.
They are making it totally frictionless to push code into the live environment, but aggressively locking down the ability to audit or challenge that code once it is live.
So that tension, right, that friction between the hyper-accelerated front end and the lockdown back end.
Yeah.
That's really the defining feature of the American IP network today.
It is. Let's break down the front end first, because the sheer scale of the acceleration is just unprecedented. Squires testified about the manual bottlenecks that used to plague the system.
Like trademark classification, for example.
Exactly. Historically, classifying a complex trademark application involved manual review, cross-referencing vast databases, parsing nuanced language. It was a process that routinely took 5 months of grueling administrative work.
5?
Yeah. But today, using their new agentic AI tool, that 5-month process is now a 5-second outcome.
5 seconds. That is a total paradigm shift. I mean, when you move from 5 months of human friction to 5 seconds of machine execution, you fundamentally alter the velocity of the whole network.
Precisely. And it's not just classification either. The U.S.PTO has deployed fraud detection AI that has fundamentally changed their defensive posture on the front end.
Oh, right, the purged filings.
Yeah. In just under a year, this automated system allowed them to identify and purge more than 70,000 baseless filings.
Wow, 70,000.
These were low-quality, likely automated submissions just designed to clog the registry. And the reason they are leaning so heavily into this AI subsidization is sheer volume. The hearing revealed that the USPTO was staring down this historic backlog that had swelled to 837,932 unexamined applications.
I want to pause on that number because it's staggering. 837,932 unexamined applications.
It's a system crash waiting to happen.
Exactly. If you are running a server and you have nearly 1 million requests sitting in a queue, your system is failing. You can absolutely see why they deploy the ASAP PAI. You have to clear the queue.
Right, you have no choice.
But here is where we hit the paradox and where we run straight into what we are calling the 64% discretionary chokehold.
This is the back end.
Yeah. So the USPTO has an administrative tribunal called the board. The board was originally designed by Congress as a highly efficient administrative off-ramp.
An audit mechanism.
Right. If a bad patent got approved, you didn't have to spend millions in a federal court to kill it. You could just go to the board, present your evidence to technical experts, and get the buggy code deprecated quickly.
But right now, the USPTO is utilizing a specific statutory mechanism, 35 U.S.C. 316B, to effectively shut those doors.
Just slamming them shut.
Yeah. The director has centralized authority and is using discretionary denial to reject 64% of all challenges that arrive at the board.
They are refusing to even institute a review.
Exactly. Why build a system that clears the front-end queue at lightning speed, only to build a 64% firewall against the audit mechanism?
So what's the logic there? It has to come down to a philosophical shift in how this system administrator views the network, right?
It does. Squires justified this massive denial rate by pointing to the economy and integrity of the IP system. The primary justification for the firewall relies heavily on preventing what the agency calls unsettled expectations.
Unsettled expectations.
Yeah. And to translate that into our system's architecture lens, we really need to talk about zombie code.
Zombie code. I love this concept. But explain exactly how a legal document acts like zombie code in a commercial market.
Think about how a startup scales. You map the IP landscape, you ensure you aren't infringing on any active, heavily enforced patents, and you deploy your product. You build infrastructure, hire teams, acquire customers.
Right, you're building a real business.
And you operate under the assumption that the legacy code-like old patents that are dormant, abandoned, or held by defunct companies is effectively dead.
Because nobody's using it.
Exactly. But then an assertion entity buys up those dormant patents. They revive them, recompile the legal arguments to map onto modern technology, and aggressively weaponize them against current market participants.
Oh, wow. So that is zombie code.
That's zombie code. Suddenly, the infrastructure you built, assuming a clear runway, is under attack from a patent filed 20 years ago for some vaguely similar process.
So the director is arguing that if the board institutes a review every single time someone challenges a patent, it basically creates a playground for endless destabilizing attacks.
Yes. It means no patent is ever truly settled, which spooks investors and destabilizes the entire market.
Okay, so the 64% firewall is designed to force finality. It is telling the market, hey, once a patent is issued, it is extremely difficult to challenge administratively. You just have to assume it's valid and structure your business around it.
That's the administrative goal, yeah.
But wait, let me push back on that architectural logic for a second, because this is where the system feels incredibly fragile to me.
Go for it.
If you are the system administrator, which the director effectively is, and you are actively using the ASAP AI pilot program to hyper-accelerate the front-end deployment of code, you are inevitably going to push bugs into production.
It's mathematically guaranteed?
Right. You cannot compress human review to 5 seconds without a massive increase in false positives. And Chairman Issa explicitly raised this critical point during the hearing.
He really went after the reality of modern patent applications.
He did. Because patents are no longer simple mechanical diagrams of a new type of mousetrap. They are exponentially longer, incredibly dense, vastly more complex. Sometimes they contain thousands of distinct claims regarding really abstract software processes.
And human examiners, who are already incredibly stressed and lacking resources, only have about 17 to 18 hours on average to review an entire application from start to finish.
That's crazy. 18 hours to read, comprehend, search prior art, and validate 1,000 claim technical document.
Impossible.
Yeah.
Exactly. Chairman Issa asked the obvious question. Are these examiners going to get 1,000 claim patent perfectly right in 18 hours? And he concluded the answer is definitively no. Errors are guaranteed.
So if you know your accelerated pipeline is deploying buggy code into the live system, why would you deliberately build a 64% firewall that locks the very audits designed to catch and deprecate those bugs?
Right. I look at this and I just have to ask, is this discretionary denial rate a deliberate feature to protect incumbents, or is it a catastrophic flaw in the system design that is just going to choke the market with invalid patents?
Well, to understand whether it is a feature or a flaw, you have to look outside the internal mechanics of the USPTO. You have to look at the threat vectors the administrator is actually trying to mitigate.
Right, the macro environment.
Exactly. The USPTO is not operating in a vacuum. They are operating in a highly hostile global environment where foreign entities are actively trying to flood the zone. Yeah, during the hearing, the representative from South Carolina pointed out that nation-states, particularly China, actively attempt to undermine the American IP system through sheer volume.
They incentivize their domestic companies to file massive amounts of low-quality patent applications in the U.S.,
hoping to overwhelm the examiners and slip broad, sweeping claims into the registry. It's basically a brute force attack on the database.
Precisely. And to combat this, the USPTO hasn't just built the discretionary denial firewall at the board. They've also engineered a massive friction point on the front end as well.
Oh, the U.S. practitioner rule.
Yes. They instituted a strict rule requiring U.S. practitioners for filings.
Let's define that for the engineers listening. What does that actually mean in practice?
It means that if you are an entity located outside the United States, you cannot simply log on to the USPTO portal and file a patent or trademark application yourself.
You can't just spin up an account.
No. You cannot even use a foreign attorney. You must hire an interface through a registered U.S. practitioner, a lawyer or agent, admitted to practice before the U.S. Patent Office.
So in network terms, this acts as a strict whitelist. Only authorized nodes, the U.S. practitioners, can commit code or execute commands on the registry.
Exactly. And this ties back to that concept of Rule 11 accountability we mentioned at the start.
Right. For the CPOs tuning in, think of Rule 11 as the ultimate user ban hammer.
That's a great way to put it.
In the U.S. legal system, Rule 11 of the Federal Rules of Civil Procedure and its equivalents in administrative law requires that an attorney sign every single pleading or motion.
And by signing, they are certifying that, to the best of their knowledge, the filing is not frivolous, it has evidentiary support, and it is not being presented for any improper purpose, like harassment or delay.
Right. If a lawyer violates this, the court or the agency can financially sanction them, suspend them, or effectively destroy their entire career.
And that is the mechanism of the air gap. By forcing foreign entities to use U.S. practitioners, the USPTO is leveraging Rule 11 to protect the registry.
Because a foreign state actor might not care about submitting 10,000 fraudulent AI-generated patents, but the U.S. attorney whose signature goes on those documents, they care deeply.
Their livelihood depends on their license. The system relies on the authorized node to filter out the malicious traffic before it ever hits the server.
Okay, so if I am a CTO sitting in Berlin or Tokyo or Seoul, how do I map this initial reality?
It means you must completely update your mental model. The American IP registry is no longer a neutral, passive database that simply records inventions.
Right. It's an active, highly defensive topology.
Yes, it has been air-gapped by the practitioner requirement. And if you identify a patent, a piece of buggy IP code that directly threatens your global deployment, and you try to trigger an audit at the board to clear your path, you are hitting a fortified wall.
You have a less than 40% chance of even getting the system administrator to look at your request.
Exactly. The default stance of the network is now defensive rejection.
Okay, so the doors are bolted shut. But that transition to a hyper-defensive posture, it wasn't arbitrary, right? Bureaucracies don't just wake up one morning and decide to lock down 64% of their traffic for no reason.
No, they don't.
If the USPTO has locked down the standard audit pathways, we have to look at how we got here. And it was triggered by a specific catastrophic exploit in the system.
The VLSI exploit.
Yes. Let's shift to the vulnerability of anonymous proxies, and specifically the VLSI patent challenge brought up by the representative from Texas during the hearing, because this is just a fascinating case study in system manipulation.
The VLSI case really is the Rosetta Stone for understanding why the USPTO felt compelled to alter the network topology so drastically.
So what happened?
To understand the exploit, you have to follow the sequence of events because the timing is everything here. VLSI is a patent-holding entity. They do not manufacture chips. They just hold patents related to semiconductor technology. They took a major semiconductor manufacturer, NXP, to a federal district court in Texas, claiming NXP infringed on a highly valuable VLSI patent. And VLSI won. They won a massive jury verdict.
And a jury trial in Texas over semiconductors is an incredibly high-stakes, multi-million-dollar environment. So VLSI basically proved their patent code holds up under intense scrutiny. They have fully validated their asset.
Exactly. The patent survived the crucible of an Article III district court. But almost immediately after that victory was announced, two entirely unknown, newly formed entities emerged out of nowhere.
OpenSky and PQA.
Yes. And these two entities immediately filed administrative challenges against that exact same VLSI patent at the board.
Right, so they bypassed the federal court and went straight to the USPTO's administrative off-ramp to try and invalidate the patent that had just won a massive verdict.
And the crazy part is, no one knew who they were.
Yeah, the representative from Texas pointed out during the hearing that the founders, the backers, the funding sources of OpenSky and PQA remain largely unknown to the public. They were just ghosts in the machine.
Even Director Squires admitted on the record, under oath, that he did not know who was behind them.
From a systems architecture perspective, this is a classic network exploit.
It really is.
Because these entities were completely anonymous, they functioned as shell proxies. They allowed unknown actors, maybe competitors, maybe short sellers, maybe foreign entities, to tie up valid, court-tested IP code in endless administrative processing.
In network security terms, this is perfectly analogous to a decentralized denial-of-service attack, a DDoS.
Exactly. You have a highly valuable target, the VLSI patent. Instead of attacking it directly and exposing yourself to legal risk, you use anonymous, decentralized shell nodes to flood the administrative system with challenges.
You exhaust the target's financial and legal resources, and you create perpetual instability around their asset. It was a massive structural vulnerability that allowed serial, asynchronous attacks without any accountability.
So you have ghost nodes launching DDoS attacks on validated code. The system administrator cannot allow that to continue.
No, the USPTO had to deploy a patch.
And according to the hearing, they deployed two major architectural updates to close this specific vulnerability. Let's walk through them. First, they reinstated what is known as the Corning Optical precedent.
Right, which demands strict real party in interest disclosures, or RPI.
Explain how that works.
This was the first vital step to breaking the proxy exploit. In corporate law, an entity can be structured through layers of Delaware LLCs, offshore holding companies, blind trusts. It is very easy to obscure the actual human beings or corporations directing the entity.
Right. Plausible deniability.
The Corning Optical precedent basically states that the USPTO will not allow that opacity anymore. If you file a petition to challenge a patent at the board, you can no longer hide behind an anonymous proxy server.
The system now demands to know exactly who is executing the attack.
You have to disclose the root entity, the financial backers, the real party in interest. If you refuse or if you obscure the truth, your challenge is just dismissed. The system demands total visibility.
Transparency is a defense mechanism. It makes perfect sense. If you pull off the mask, the DDoS attack loses its primary advantage. But the second patch, that is what has fundamentally altered the rules of engagement for every scale-up listening right now.
The one join and done doctrine.
Yes, this implementation of one join and done. Talk about how that changes the topology.
This is where the topology gets highly restrictive. Under the previous rules of the board, a single patent could face multiple serial challenges. A competitor could literally launch an attack, see how the patent owner defended it, learn from the failure, and launch a second attack with a refined argument.
That's insane.
We saw cases where a single patent faced as many as 7 serial challenges. It was an endless loop of administrative warfare.
Which is an absolute nightmare if you actually invented the technology and just want to build your company.
Right. So Director Squires and the USPTO implemented a new doctrine. Squires clarified during the hearing that the new rule isn't strictly one and done, meaning only one company ever gets to challenge a patent. Rather, it is one join and done.
Okay, so what's the difference?
The USPTO maintains what they call liberal joinder provisions. This means if Entity A launches a challenge against a patent, the USPTO opens a window. Other entities, entity B, C, and D, can join that specific petition. They can pool their resources and arguments.
What?
But the days of launching sequential asynchronous attacks on the same target are permanently over. The USPTO is demanding that all challengers gang tackle the problem at the exact same time in a single proceeding.
Once that singular unified challenge is adjudicated by the board, the patent achieves quiet title. The issue is closed. Finality.
Exactly.
Finality.
Okay, I understand the desire for finality from an administrative standpoint, but let me put my CTO hat back on, because when I look at this one join-and-done mechanism, I see a massive, glaring race condition being injected into the network.
Explain how you see the race condition forming. Well, let's say there is a terrible, overbroad software patent out there. It's essentially buggy code that threatens my entire technology stack. My scale-up in Berlin has the engineering resources and the prior art to completely invalidate it. We're building a bulletproof challenge.
Okay, you're prepping a solid audit.
Right. But before we are ready to file, a poorly resourced proxy, or just a really incompetent actor, files a structurally weak challenge against that same patent. They rush to the board with a bad argument.
The clock immediately starts.
Exactly. Because of one join and done, I now have an incredibly compressed time window to scramble my legal team, integrate my arguments into their petition, and join their flawed attack.
Yes.
If I miss that highly compressed window, if I fail to join in time, am I permanently locked out?
Yes.
Does a weak first strike by an incompetent actor permanently insulate a bad patent from my structurally sound audit later?
Your analysis is exactly correct, and that is the exact risk of this architectural patch. By demanding finality, the system forces collective action within an arbitrary time constraint. If you miss the joinder window, the USPTO assumes the matter is settled. The system assumes the code is clean, regardless of whether the initial audit was competent or thorough.
For a CTO or a general counsel, this fundamentally changes your operational posture. It means your threat intelligence has to be operating in real time.
You can no longer wait for a patent troll to assert a patent against you before you begin drafting a defense.
You must be constantly monitoring the registry for initial filings against patents that map to your technology stack, ready to deploy resources the moment some weak actor triggers the countdown.
It is exhausting just thinking about it.
Truly. Now, we must note, and we are going to do this completely neutrally as system analysts, that this specific one join and done patch is highly contentious across the political spectrum in the U.S.
Very contentious. Lawmakers from both the left wing and the right wing are deeply divided on the structural impact of this rule.
Right, and we are not taking sides here. We are just reporting what was said.
Exactly. The dividing line is fascinating, though, because it pits two valid concerns against each other. Some lawmakers, aligned with the director, argue this doctrine is an absolute necessity. They view it as a critical defense mechanism to protect American manufacturing and domestic innovation.
Their argument is that foreign state actors and massive tech conglomerates use endless administrative warfare, those serial challenges we discussed, to bleed smaller U.S. companies dry. One join and done protects the little guy from being crushed by legal fees.
But on the flip side, other lawmakers are vehemently opposed, and they are supported by massive technology coalitions. The hearing specifically mentioned opposition from the Alliance for Automotive Innovation and the Business Software Alliance.
Those are heavy hitters.
They are. These groups argue that this discretionary lockdown consolidates dictatorial power in the hands of the USPTO director. They argue that by creating this race condition and heavily restricting audits, the USPTO is artificially insulating low-quality, overbroad patents.
And when bad patents are protected, it drives up consumer prices, impedes competition, and stifles software development.
Right.
Our objective is solely to map the structural reality you face. And the reality is this: the board, the primary cost-effective administrative audit pathway, is now heavily restricted.
It is choked off by the one join and done synchronization requirement. It demands strict RPI transparency, and it is governed by a 64% discretionary denial rate.
So if the USPTO has effectively bolted the administrative door shut, these bad actors and even legitimate competitors aren't just going to give up. Water finds a crack. If the network traffic is blocked at the board, where's it being rerouted?
It is being routed straight into the federal courts, specifically Article 3 district courts, and that is a much, much more dangerous environment.
Which brings us back to the core of the nightmare scenario I outlined at the very beginning of this deep dive. Let's explore the threat topology of the Article 3 discovery warfare trap.
We need to establish the baseline first, the cost disparity between these two execution environments. Chairman Issa and Representative Klein laid out the math explicitly during the hearing.
Right, taking the administrative off-ramp, successfully getting your case heard at the board costs approximately $500,000 in legal and administrative fees.
That is a lot of money for a scale-up, but it is a predictable, manageable business expense.
But if you are denied at the board, or if the one join and done window closes, and you are dragged into an Article 3 district court battle, the financial metrics explode.
The baseline cost for district court patent litigation is upwards of $5 million. It is a 10x multiplier in resource burn minimum.
Okay, I need to ask the ELI 5 question here. Explain like I'm 5. Why does a district court case cost $5 million? What are the lawyers actually doing that consumes that much capital? It cannot just be filing paperwork.
It is definitely not the paperwork. The $5 million cost is driven almost entirely by one word: discovery.
Discovery.
When you enter an Article 3 federal court, the U.S. rules of civil procedure grant both sides incredibly broad powers to demand information from each other. This is not like a criminal trial where you wait for the police to find evidence.
Right.
In civil discovery, opposing counsel can legally compel you to hand over millions of internal documents. They will demand forensic imaging of your servers. They will demand every email your engineer sent regarding the product.
Your Slack channels, your source code repository.
All of it. They will force your lead developers to sit for days of depositions answering hostile questions under oath, and your legal team has to manually review every single one of those millions of documents to ensure you aren't accidentally handing over attorney-client privileged information.
Oh man, so you are hiring armies of forensic data experts and contract lawyers to sift through your own infrastructure. Yeah. That is where the $5 million goes.
Exactly. It is a massive operational drain. You aren't just paying money, you are losing thousands of hours of your best engineer's time.
But it gets worse. It is not just the financial and operational cost, it is the strategic exposure.
Yeah.
And foreign entities are keenly aware of this disparity and are actively leveraging it.
They absolutely are.
Consider the macro data presented in the hearing. 4 of the top 5 U.S. patent recipients in the last year were foreign entities. Non-practicing entity, or NPE, filings in district courts rose by 18.7%.
Let's define NPE for the audience. A non-practicing entity is a company that holds patents but does not actually manufacture products or provide services based on those patents. They are purely enforcement vehicles.
Often, they are referred to pejoratively as patent trolls.
Right. And the hearing highlighted a chilling statistic. Huawei, the massive Chinese telecommunications company, recently transferred nearly 1,000 patents to various assertion entities targeting American companies.
But the most critical, terrifying example of this new threat topology was brought up regarding U.S.C Memory Technologies, or YMTC.
The YMTC versus Micron case is the perfect encapsulation of how the architecture becomes weaponized. To understand the stakes, you have to know who YMTC is.
Who are they?
U.S.C Memory Technologies is a Chinese state-owned semiconductor manufacturer. They are currently sitting on the U.S. Department of Commerce's BIS entity list.
The Bureau of Industry and Security entity list. Being on that list means the U.S. government has explicitly designated you as a national security threat. U.S. companies are heavily restricted from exporting technology to them. They are effectively blacklisted from the U.S. supply chain.
Correct. They are a sanctioned entity. Yet right now, YMTC is utilizing the U.S. federal court system to sue Micron, one of the largest American memory chip manufacturers.
This is the part that makes my head spin. How does a sanctioned entity, recognized as a national security threat, use the host nation's own court system to attack a domestic manufacturer?
They do it by exploiting the mandatory discovery process we just detailed. When YMTC sues Micron in an Article 3 court, the court rules dictate that Micron must participate in discovery.
Right, they have no choice.
YMTC is using this process not necessarily because they believe they will win a clean legal victory at trial in 5 years. They are utilizing the lawsuit as a sanctioned extraction protocol.
They are weaponizing the federal rules of civil procedure to compel the disclosure of Micron's highly sensitive trade secrets.
Exactly. By demanding access to Micron's technical schematics and source code to, quote-unquote, prove infringement, they gain unparalleled visibility into the proprietary architecture of their biggest competitor.
This is why I called it an aggressive, mandatory honeypot. If you deploy your technology in the U.S. market, Your adversaries do not need to hire elite hacker group to breach your firewalls. They do not need to deploy zero-day malware.
They just need to acquire a vaguely relevant patent, file a lawsuit in a federal district court, and sit back while the United States legal system forces you to package up your source code, your internal documentation, and your strategic roadmaps and hand it over to them on a silver platter.
The discovery phase itself is the extraction mechanism. The lawsuit is just the key to unlock it.
And here is the truly insidious part. The USPTO's own rules are inadvertently funneling certain state-backed actors straight into this honeypot.
Oh, right, the Tienma decision.
Yeah. During the hearing, Director Squires discussed the Tienma decision. This was an administrative ruling that reinforced a previous Supreme Court precedent known as return mail.
Walk us through the legal logic of return mail and Tienma.
In the return mail case, the Supreme Court ruled that a United States government agency is not considered a person under the American Invents Act. And since only a person can petition the board for a patent review, U.S. government agencies cannot use the PTO.
Okay, that makes sense for domestic agencies.
Right. But the USPTO, through the Tienma decision, took that logic and extended it globally. They ruled that foreign sovereigns and foreign state actors are also not considered persons. Therefore, if a real party in interest disclosure reveals that a foreign state actor is backing a challenge, they are immediately barred from the board. They are legally locked out of the $500,000 administrative environment.
So if they are locked out of the board, they cannot challenge a patent administratively. But they still want to attack the competitor. What is their only remaining option?
Their only option is to initiate litigation in the Article 3 district courts.
Wow. So the rules effectively mandate that state-backed actors use the federal courts, where discovery warfare is the weapon of choice.
Exactly.
For CTOs outside the U.S., this represents a massive, almost insurmountable structural barrier. Think about the implications. If your entire competitive advantage relies on optimizing for trade secrets, if your core architecture is based on stealth, on code that is never published, never patented, just kept locked down in your repositories, and you get dragged into a U.S. district court by an NPE or a competitor.
Your entire system architecture is exposed.
Your code, your proprietary logic, your internal engineering communications, all of it becomes subject to the discovery extraction protocol.
Which leaves the CTO in an impossible bind. If you face a bad patent, the board is blocking 64% of challenges and demanding impossible one join and done synchronization. If you go to district court, you enter a $5 million mandatory honeypot that extracts your trade secrets.
The system is just heavily weighted toward protecting the existing network nodes, the incumbent patent holders.
It is.
Okay, so let's say I'm that CTO. I see the trap. I know I cannot risk the Article 3 discovery extraction. I know the board is a statistical long shot. Are there absolutely any other pathways to clear a bad piece of IP code off the registry?
Well, during the hearing, Director Squires pointed to a third option. He suggested a mechanism called ex parte reexamination as a viable alternative for companies trying to clear the path.
He did. Squires vigorously defended ex parte reexamination. He claimed that the USPTO has made the process much quicker and that it offers a similar outcome experience to the board, allowing challengers to invalidate bad claims without going to court.
However, Chairman Issa pushed back fiercely against this characterization, and Issa's criticism highlighted the deep, fundamental structural flaws of this alternative pathway.
To understand why Issa was so critical, we need to analyze ex parte as a fundamentally different execution environment compared to the board. Let's break down those mechanics.
Let's start with what we know. An inter partes review, or IPR, which happens at the board. When you file an IPR, it is an adversarial process. It looks like a trial.
Right. Both sides, the challenger trying to kill the patent and the patent owner defending it, get to present evidence, submit expert testimony, cross-examine witnesses, and argue before a panel of highly trained technical judges. It is an open debate.
But ex parte reexamination is fundamentally different. It is a closed-loop conversation. Chairman Issa described it perfectly during the hearing. In an ex parte proceeding, there are exactly two people in the room, the original inventor and the USPTO examiner.
And often it is the exact same examiner who erroneously granted the buggy code in the first place.
That is the crucial structural downgrade. It removes the adversarial check on the system. As a third-party challenger, say, our CTO in Berlin, you submit your petition for ex parte reexamination. You package up your best prior art, your detailed technical arguments as to why the patent is invalid, and you hand it to the USPTO.
And then what?
The moment you submit that packet, you are immediately and permanently removed from the execution environment. You have zero visibility into the proceedings and zero input as the process moves forward. It becomes entirely non-adversarial from your perspective.
I equate this to a junior developer submitting a critical security flaw to a massive bureaucratic software vendor.
Oh, that's a good analogy.
Imagine you find a zero-day vulnerability in their core product. You write up the documentation, you create the reproducible code, and you submit it via their bug bounty portal. But the moment you hit submit, you are permanently locked out of the Slack channel where the vendor and the original developer secretly decide if the flaw is real.
You don't get to see their defense.
No, you don't get to counter their patches. If they say, actually, it's not a bug, it's a feature, you can't argue back. You just sit in the dark for months waiting for an outcome report that you have no power to influence.
And because of that closed-loop architecture, Chairman Issa argued that ex parte proceedings overwhelmingly favor the reinstatement or continuation of the substantially same patent.
Of course they do.
The patent owner gets to have private, iterative conversations with the examiner. They can subtly tweak the language of their claims, narrowing them just enough to sidestep the prior art you submitted while still keeping the patent alive and dangerous.
For an overseas scale-up, triggering ex parte is a massive strategic risk.
Yeah.
You are firing a missile, handing over your absolute best intelligence and prior art, and immediately losing all telemetry data. You cannot course correct. It is a blind deployment into a system that is statistically biased toward the incumbent code.
Exactly.
So to summarize the back-end architecture regarding patents so far, the primary administrative audit pathway, the BORDED, is choked by a 64% firewall and strict synchronization rules.
The alternative administrative pathway ex parte is a rigged, blind deployment where you lose all visibility.
And the judicial pathway Article 3 courts is a $5 million discovery trap where your trade secrets are forcibly extracted.
The system is designed to lock you out or bleed you dry. It is a formidable defensive topology.
It really is.
But this weaponization of administrative systems to protect dominant networks isn't just happening in the back-end patent code. The hearing revealed that identical strategies are actively being deployed at the application layer as well.
By application layer, you mean?
I mean, the branding, the syntax, the trademarks that companies use to interface with consumers.
Which brings us to asymmetric trademark warfare and custodial shields. The hearing provided two massive case studies that show how dominant market players and even the system administrator himself manipulate the trademark registry. Let's start with the asymmetric warfare tactics of Monster Energy.
Right. During the hearing, the representative from South Carolina brought up Monster Energy as a prime example of what lawmakers termed a trademark bully. Monster Energy is a multi-billion-dollar beverage conglomerate, and according to the testimony, they are the #1 filer of trademark oppositions in the entire USPTO system.
#1 in the whole system.
Yes. They aggressively target incredibly small entities. The representative cited absurd examples. They filed oppositions against a local restaurant in Ohio called Monster Shawarma and a tiny mom-and-pop camping gear company. They attack anyone in any industry who dares to use the word monster or any syntax resembling their brand.
Wait, Monster Shawarma. Let's just pause on the absurdity of that for a second.
Yeah.
A massive multi-billion-dollar energy drink conglomerate deployed its elite corporate legal team to neutralize a local guy selling garlic sauce and falafel in Ohio.
Yeah, pretty much.
On what planet does a consumer walk into a shawarma shop and think, ah yes, this roasted meat wrap is clearly manufactured by the people who make taurine energy drinks? It sounds like pure legal pettiness.
Well, it sounds petty to a layman, but from a system architect's perspective, this is a highly calculated, ruthlessly efficient strategy of vertical saturation.
Vertical saturation.
Monster Energy is not actually worried about consumer confusion with a falafel shop. They are utilizing their massive asymmetrical financial resources to create an artificial structural barrier across the entire registry. They are flooding the zone with legal oppositions to deny any new node access to their chosen syntax.
They aren't just protecting their core energy drink product. They are claiming absolute ownership over an entire sector of the semantic network.
That is exactly what they're doing.
That is a brilliant way to frame it. When a scale-up tries to register a trademark, they aren't just filing a bureaucratic form. They are attempting to claim a distinct address on the commercial network. They need a namespace to operate.
And Monster uses the Trademark Trial and Appeal Board, the trademark equivalent of the Patent Board, to enforce the saturation. They know the shawarma shop cannot afford $50,000 in legal fees to defend their name, so the shop surrenders the name.
Monster ensures no other entity can establish an address, even tangentially related to their namespace. It's a brute force resource exhaustion attack against smaller, defenseless nodes.
Exactly. And it demonstrates that the administrative pathways are easily hijacked by entities with overwhelming capital. But the hearing revealed something even more unprecedented regarding trademarks.
Yeah.
We saw how the system administrator, the director himself, can manually intervene in the network to protect specific entities.
Let's discuss the Board of Peace custodial shield.
Yeah.
Because this was the most explosive revelation from the entire hearing. Let me set the stage, because when I first read this, I was genuinely confused.
Go ahead.
The USPTO director, Kathy Vidal's successor, Director Squires, personally filed a trademark application for the phrase Board of Peace. The Board of Peace is an entity associated with President Trump, which Representative Raskin noted during the hearing was allegedly receiving billions of dollars from foreign governments.
The mechanics of how this filing occurred are critical to understand the power of the administrator here. Director Squires testified that President Trump announced the formation of the Board of Peace. A mere 8 minutes after that public announcement, an opportunistic cyber squatter went online and grabbed the domain name boardofpeace.org, attempting to hijack the namespace.
8 minutes.
Yeah. Squires testified that he saw this happening and immediately stepped in. He personally filed the trademark application for the Board of Peace, using his authority to secure the trademark as what he called a custodial shield. The goal was to prevent identity theft before the actual organization had even been formally incorporated or had the chance to file for themselves.
Wait, hold on. I need to stop you there. I want to make sure I'm understanding this correctly. The system administrator of the United States Patent and Trademark Registry just manually stepped in and filed a trademark himself for a political entity.
He did.
I thought the registry was supposed to be a neutral, passive database where applicants submit their forms and wait in line. How does a system admin just manually step in, bypass the queue, and claim a namespace on behalf of someone else? And didn't he waive the fee too?
Yes. He requested and granted a waiver for the standard $350 filing fee, stating he was acting in a custodial intergovernmental capacity. And your confusion mirrors the outrage expressed by several lawmakers.
Let's look at the arguments impartially. Left-wing lawmakers, led by Representative Raskin, were furious. They accused the USPTO director of severely violating the Lanham Act. The Lanham Act is the foundational piece of U.S. federal trademark law. Raskin argued that under the Lanham Act, a third party simply cannot file a trademark on behalf of someone else unless they are their formal legal representative, which Squires explicitly claimed he wasn't.
Right. And Raskin went further. He framed the Board of Peace as an unconstitutional slush fund violating the emoluments clauses of the Constitution. He accused Director Squires of acting as a political operative, utilizing the machinery of the USPTO to create a monopoly on the word peace for the president.
Raskin also astutely pointed out that there are dozens of prior existing legitimate organizations with peace in their name, like Greenpeace or the World Peace Network. He argued that by granting this broad custodial shield, the administrator was putting all those existing nodes at risk of being targeted by the newly shielded entity.
Conversely, right-wing lawmakers and Director Squires vehemently defended the action. They argued this was a necessary, completely lawful intervention. Squires cited his specific authority under 35 U.S.C. Section 3.
Which does what exactly?
This statute tasks the USPTO director with advising the president on national security and intellectual property policy. Squires argued that the Board of Peace was an emerging international organization tied to national security. He maintained that he was acting strictly as a custodian, placing a temporary protective lock on the syntax to protect this vital entity from immediate bad faith exploitation by a cyber squatter. He framed it as protecting the integrity of the network from malicious actors.
The structural reality is what matters.
The reality is that the system administrator has the statutory authority and the willingness to manually override the queue, to waive standard fees, and to deploy custodial shields to protect specific entities based on national security concerns or executive branch priorities.
Which brings us to the ultimate question for our audience. If the system allows massive corporations like Monster Energy to enforce vertical saturation and crush small nodes through resource exhaustion, and simultaneously allows the system administrator to manually deploy custodial shields to protect chosen entities, how can a foreign scale-up possibly trust the neutrality of the registry?
The brutal truth is, you don't. You don't trust the neutrality. Trust is not a component of systems architecture. You do not build a server architecture trusting that hackers will leave you alone. You build firewalls.
Right.
In the IP space, you map the topology, you identify the choke points, and you build redundancies. You operate with the explicit understanding that the administrative boards, both for patents and trademarks, can and will be used to exhaust your resources just as effectively as the federal courts. You must architect your brand deployment assuming that dominant nodes will deploy asymmetric resource attacks against your syntax the moment you gain market traction.
So let's pull all of these complex threats together and synthesize the threat landscape. The American USPTO architecture has fundamentally shifted. The front end is hyper-accelerated by AI subsidization. The ASEP AI program is compressing prior art searches to 5 seconds and clearing backlogs at record speeds, inevitably pushing untested, potentially buggy IP code into the live environment.
But the back end, the audit mechanism, is completely locked down.
Yes, it is defended by a 64% discretionary firewall, strict U.S. practitioner whitelists, RPI disclosures to block anonymous proxy attacks, and the unforgiving one-join-and-done synchronization doctrine that forces a race condition on any challenger.
And if you find yourself targeted by bad code and you try to bypass that back-end firewall, you face terrible options. You either drop into the closed-loop ex parte downgrade, where you fire your best prior art blindly into a system biased toward the incumbent and lose all telemetry data.
Or worse, you get trapped in the $5 million Article 3 discovery warfare zone. That is where state-backed entities like YMTC, locked out of the administrative system, use the federal legal process as a sanctioned protocol to legally extract your most sensitive trade secrets and source code.
It's a daunting landscape.
Which brings us to our final directive for this deep dive. If you are a founder, a CTO, or an engineer building a scale-up outside the U.S., you must heed this exact mandate. Access your own IP portfolios not merely as legal documents, but as structural deployments in a rapidly fracturing global network.
And I will leave you with one final architectural puzzle to consider. We have mapped how defensive and hostile this network has become. If Article 3 federal courts are now being used as mandatory honeypots to extract trade secrets during discovery, what if the most advanced use of an intellectual property portfolio isn't enforcement at all?
Okay, where are you going with this?
What if instead of trying to patent your core technology, you should be architecting your patents as an air-gapped decoy network?
No.
Think about it. A sacrificial layer of patents designed specifically to attract competitor attention, absorb their legal attacks, and legally exhaust their capital resources in the courts, while your actual mission-critical logic remains entirely undocumented, unpatented, and hidden in the dark.
A decoy network built out of legal code. Now there is a thought for system architects to keep them up at night. Until next time.